Hi, a very good day to everyone that is watching this. Today, Fawai King, and my group members will be presenting on undue influence. Firstly, I will be talking about undue influence in the English law. In the English law, there are three main elements to the doctrine. The first element is the statement of the mind of the innocent party. Basically, this element talks about how impairment of decision making due to excessive reliance and dependence on another party can cause undue influence. The second element is the defendant's conduct. This is seen in the case of R and Attorney General of England and Wales. In this case, Lord Hoffman states that undue influence has concentrated in particular upon the unfair exploitation by one party of a relationship which gives him ascendancy or influence over the other. In the last element, the third element, public policy, in the case of Pistachio and Webb, Lord Mummery states that public policy is confirmed as an element of undue influence. Moving on, there are two classifications of undue influence. The two classifications is first, actual undue influence, which is class 1, and 2, which is presumed undue influence, which is class 2. And in presumed undue influence, there are two subcategories. I will be moving on to the Malaysian law of
Tanggal 31 bulan 8 57 Merdeka, merdeka, tetaplah.
What is undue influence in Malaysian law? Basically, section 16, subsection 123 talks about how one party that is in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other can become undue influence. So, what are the differences between English law and Malaysian law? Well, in Malaysian law, there are no clear distinction between actual and undue influence. The subsections explains the need of relations subsisting between the parties, whereas in English law, it is not necessary. Also, there is no emphasis on the difference between actual and presumed undue influence in the Malaysian law compared to the English law. Now I will be passing on to my other group members to present.
Hi, I'm Karina. Today I'm going to present on actual undue influence. There was a case, Williams and Bailey, where a young man had forgot endorsement on promissory notes and had caused a bank to lose money as a result. The bank then approached the young man's father and impliedly threatened to prosecute the young man unless he took personal responsibility for monies paid out. The House of Lords had declared that there was no valid agreement between the young man's father and the bank, as the pressure given was amounted to actual undue influence. So, now the problem is, what is actual undue influence? The definition of undue influence was given by Twitter in the law of contract. Actual undue influence involved cases in which one party had induced the other to enter into the transaction by actual pressure which equity regarded as improper, but which does not amount to duress at common law because no element of violence to the person was involved. And there's no further requirement that the transaction be shown to be to the manifest disadvantage of the party seeking to set it aside, or that the transaction must be one that calls for an explanation by the other party. Furthermore, there's another different definition of actual undue influence given in case law. In the case of Alcott and Skinner, 1887, Lord Justice Linley described actual undue influence as some unfair and improper conduct, some coercion from outside, some overreaching, some form of cheating. In order to sue under actual undue influence, there are a few elements needed to be established. These elements were set up by Lord Hothouse in the case of Royal Bank of Scotland and Ettridge, 2002. Firstly, it is an equitable wrong committed by the dominant party against the other. Secondly, it must be unconscionable for the dominant party to enforce his legal rights against the other. Thirdly, there must be some express conduct overbearing the other party's view. Fourthly, actual undue influence does not depend upon some pre-existing relationship between the two parties. And lastly, he who goes actual undue influence must prove it. The law on undue influence in Malaysia is provided in Section 16 of Contracts Act. Section 16 has embodied the English equitable doctrine. The traditional categories of actual and presumed undue influence can be seen in the provisions where the courts have applied Section 16 sub 1 for cases of undue influence. Section 16 sub 1 of Contract Acts provide as follows. A contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in a position to dominate the view of the other and uses that position to obtain unfair advantage over the other. Under 16 sub 1, both elements must be satisfied to establish. Firstly, the relation subsisting between the parties are such that one person is in a position to dominate the view of the other. This was illustrated in the case of HSBC and Syarikat United Law Enterprise in 1993. On the facts, G was unable to prove S was in a position to nominate his view. G has insisted that S come over to G's office with the guarantee for G's signature rather than going over to S office when S asked him to do so. Secondly, the dominant person used that position to obtain an unfair advantage over the other. This was made clear in the case of Pusatturai and Kanapa Chettiar, where the Privy Council held that it is not sufficient to have mere influence. The influence must be undue in the nominant person has used his position to obtain an unfair advantages. In conclusion, the law uses in Malaysia is similar to English common law, just the provisions applied are different.
I am Tan Suan, and I will be presenting about presumed undue influence. In presumed undue influence, there is no need for the claimant to prove that actual undue influence was exerted by the other party. Once a relationship of trust is proven, the burden automatically shifts to the defendant to prove that the claimant actually entered the contract on his own free will. There is two limbs to presumed undue influence, where first there is a special relationship and the other is when there is no special relationship. As shown in the slides, when there is a special relationship, it is only required for the claimant to prove that there is any sort of fiduciary relationship. Once this is proven, courts will irrebuttably presume that there is indeed existence of undue influence. In the other situation where there is no special relationship, as long as a relationship of trust and confidence is proven to be relied on the other party, undue influence will be presumed. As said by Lord Nichols in the case of Royal Bank of Scotland and Attridge, to sue under presumed undue influence, three elements must first be established. The first, if there is a relationship, it must be shown that the victim is reposing trust and confidence to the other party. The second one, if there is a special relationship, it is presumed that undue influence is existing. Finally, if there is no special relationship, a victim must show that there is presence of trust and confidence relied on to the other party. It is a relatively easy pathway to prove for presumed undue influence because once there is a special relationship, undue influence is presumed. Special relationships would include parent and child, solicitor and client, doctor and patient, etc.
Hello, my name is Kelvin Low, and I will be speaking on the topic of presumed undue influence, specifically presumed undue influence with regards to Malaysian law. In Malaysia, the law is not clear regarding the distinction between actual and presumed undue influence, and as such, it generally follows the English law in this regard. Particularly, Section 16, subsection 2 of the Contracts Act 1950 states that a person will be in a position to dominate the will of another if they were to hold real or apparent authority over the other person, if they have a fiduciary relationship with the other person, or if the other person's mental capacity has been compromised as a result of old age, illness, or mental distress. However, it falls to the victim to prove that the person had obtained an unfair advantage in the contract as a result of their ability to dominate the will of the victim. A case for this would be the case of Ibrahim B. Musa and Bahari bin Nayar, in which the plaintiff had entered into a sales and purchase agreement with the deceased and would later come to sue the estate of the deceased due to a breach in the agreement. The court held that there was no undue influence as the claimants had not obtained an unfair advantage over the deceased despite having been in a position to dominate her will.
To explain the cases, in the English case of Alcott and Skinner, Alcott had donated all her assets to the sisterhood which she joined. Due to the rules of the sisterhood, she transferred them to Skinner, the lady superior. But later, when she withdrew from the sisterhood, she wished to recover her assets. So the issue here was, can Alcott claim for recovery by falling under undue influence? It was finally held that yes, she can, because there is indeed a special relationship between a religious leader and her disciple. But sadly, she was barred by lectures, so there was no recovery granted. In the Malaysian case of Tan Giat Luang and Tan Li Kiao, the plaintiff, which is the daughter of the deceased, and the defendant, who is the daughter-in-law of the deceased, were involved. The defendant's husband, who lives with the deceased, was proven by the plaintiff that the defendant's husband had indeed brought the deceased to see lawyers to transfer the land that would be included in her will. Since the deceased is certified to be suffering from senility, where her old age causes loss of mental faculties, it is finally proven and held that there is indeed presumed undue influence with special relationship of a mother and child. Since the son had used his relationship with his ill mother to dominate her will, the plaintiff's claim was then allowed.
I will now speak on the topic of confidence and trust regarding presumed undue influence. In the English case of Credit Lyonnais Bank, Netherlands N.V. and Burge, the defendant had worked for her employer for such a long time and as a result built a relationship of confidence and trust with him, occasionally babysitting his children whenever he went on holidays. As a result, when her employer asked her to sign her flat up as security for a loan the company was taking out, she agreed to do so, despite not knowing that the company's loan totaled at £270,000. At the same time, she also did not seek independent legal advice, despite being told to do so by the bank. As such, when the bank sought to repossess her apartment, she raised the defense of undue influence. It was held by the court that the agreement of the defendant to sign her flat up as security had been obtained by undue influence, and as such the bank could not repossess her apartment as it had not taken enough steps to avoid constructive notice. In the Malaysian case of Tara Rajat Nam and Dr. Jaginder Singh and others, the first two defendants had gotten the plaintiff to sign some documents which transferred her land to the second defendant. Despite this, the plaintiff retained possession of the land, and later the two defendants would then transfer the land to a third defendant who sought to possess the land, which led to the plaintiff pleading undue influence. It was held that the relationship between a solicitor and their client is a fiduciary one, and as such, the solicitors were in a clear position to dominate her will. Therefore, the solicitors were not allowed to gain possession of her land.
My name is Pratibha Preya. Now, I will be presenting on rebutting the presumption of undue influence and the third party in undue influence based on English and Malaysian law. First, let's look on rebutting presumption of undue influence under English law. There are two definitions given on rebutting presumptions. Here, I've picked two definitions given by Trettel and Percotten Law of Justice in Alcott and Skinner. According to Trettel, the presumption is rebutted if the party benefiting from the transaction shows that the transaction was the free exercise of independent will. And according to Percotten Law of Justice in Alcott and Skinner, the court set aside the voluntary gift unless it is proved that in fact the gift was the spontaneous act of the donor acting under circumstances
which enabled him to exercise an independent will and which justifies the court in holding that the gift was the result of a free exercise of the donor's will. There's a case under this presumption, rebutting presumptions, which is Regina and AG in England and Wales. In this case, absence of independent legal advice may or may not be a relevant matter. It is not necessarily an exploitation of a relationship if one party enters into a transaction without independent legal advice. Conversely, there may be undue influence even if induced party had independent advice. The court held while the lack of independent advice available on Regina was a matter of regret, the facts of the case did not give a rise to an inference that the transaction was obtained an unfair exploitation of the relationship. Next, we'll be moving on to rebutting presumptions of undue influence under Malaysian law. There's a case in Cik Noria and Syed Ali bin Omar. In the case, an illiterate elderly infirm woman executed deed of gift giving a nephew all her landed property, leaving herself with a gross annual income of £30. When she sought to set aside the gift, the nephew laid evidence purporting to show she had received independent legal advice from a solicitor before executing the deed. In fact, the solicitor received all instructions from the nephew. The court held independent legal advice is not the only way to rebut presumptions of undue influence. On the fact, relations between the parties gave rise to presumption of undue influence, and the nephew had not rebutted the presumptions. The rebutting presumption under English and Malaysian law is the same, which says the independent advice may tip the balance but does not necessarily to do so. Next, we'll be moving on to undue influence from third party under English law. There are two conditions for a contract to be avoided where the undue influence is exerted on one party to the contract by the third party. First, the third party was acting as an agent for other party. Second, the third party had the actual notice or constructive notice of the undue influence. Under actual notice, there's a case CIBC mortgages. In this case, the fact of the case is the husband wanted to raise money to speculate on the stock market by remortgaging the matrimonial home that he jointly owned with his wife. He pressured his wife into signing a charge over their jointly owned matrimonial home in favor of CIBC. The wife did not read the charge, which stated that the loan was to refinance the matrimonial home and for husband and wife to purchase another home. Husband used the money to speculate on the stock market and suffered huge loss and fell back on the repayment of CIBC. When CIBC wanted to enforce the charge, the wife raised undue influence by the husband. The issue in this case is, can the undue influence between the husband and the wife affect the contract between the wife and the bank? The court held CIBC entitled to enforce the charge because in this case there is no actual notice. Next, we'll be moving to constructive notice. Constructive notice means that there is no notice, but the court have deemed that there is notice in order to reach an appropriate solution. Constructive notice usually applies when a party did not actually have notice of a particular event, but the court deemed such notice, usually because the party turned a blind eye or was negligent and ought to have an actual notice. There are two stages under this constructive notice. The first stage is intended charge is on the false, not advantageous to the co-owner. Second, substantial risk that the transaction has been procured as surety, committed a legal or equitable wrong. Second stage is undue influence, mispresentation or some other legal wrong by the principal debtor with regard to the surety is proven. The creditor has failed to take a reasonable steps to be satisfied that the surety entered into the obligation freely and with knowledge of the true fact. A case under this constructive notice is Barclays Bank Place and O'Brien. In this case, the fact of the case is the wife charge a property to bank based on misrepresentations made to her by her husband. The issue on this case was, could husband misrepresentation be imputed to bank so as to vitiate contract between bank and wife? The court held charge was voidable because on the fact bank had constructive notice of husband's misrepresentation. There are reasonable steps that can be taken under this constructive notice. First, warning the surety of the amount of the surety's potential liability and risk involved. Second, advising the surety to take independent legal advice. Now we're looking at undue influence from third party under Malaysian law. There's a case under undue influence can only be pleaded by third party to a contract, not the third party. In the case of Malaysian French Bank Berhad and Abdullah bin Muhammad Yusuf and others, stated that a plea of undue influence can only be raised by a party to a contract and not by a third party. A contract resulting from undue influence exerted by third party is enforceable. To conclude, under English law, it is voidable under the two conditions that I told before, and under Malaysian law, the undue influence is enforceable.
Hello, my name is Rakshana, and now I will be presenting on remedies for undue influence. So, under the English law, the primary remedy is that the courts will refuse to enforce the agreement against the person influenced. And if the person under the influence seeks rescission, the usual bars to rescission still applies. There are 4 general bars to rescission. Firstly, it's affirmation, where the person under the influence affirms the contract. Secondly, the bona fide purchaser acquires good title to the subject matter before rescission. Thirdly, it's delayed when there is a lapse of time between the vitiating factor and the action to rescind the contract. And lastly, it's when restitutio in integrum is not possible. So, when rescission is ordered, the parties will put back to their status quo as best as possible. A case that can be referred to is TSB Bank and Camfield. In this case, the wife, Mrs. Camfield, risked her matrimonial home to the extent of £15,000, which was misrepresented to her by her husband. Her liability was in fact unlimited. It was held that the bank had constructive notice of the third party's misrepresentation. In this case, the third party would be Mrs. Camfield's husband. Hence, rescission was ordered. The test used in this case was, what would Mrs. Camfield have done if she knew all the facts and circumstances leading to a transaction? So, the parties were restored to their status quo. Under the Malaysian law, there are 2 limbs under Section 20 of the Malaysian Act 1950 that gives remedies for undue influence. The first limb tells us that the agreement is voidable under the option of the party whose consent to the agreement has been caused by undue influence. And the second limb tells us that if the party entitled to a void has received any benefit, the court may set it aside, which is mentioned in the Act, upon such terms and conditions as the court may deem just. Moreover, if the victim chooses to rescind the contract, Section 65 and Section 66 of the Contracts Act 1950 applies. This section talks about consequences of rescission of voidable contract, where if a party chooses to rescind the contract, the other party need not perform any promises contained in the contract, and the party who chose to rescind the contract shall restore any benefit received. And Section 66 talks about the obligation of a person who has received advantage under a void agreement or contract that becomes void. This section simply means that both parties will have to restore or make any compensation received from each other. So, basically, for remedies, both Malaysian and English courts may order rescission. And when it comes to differences, bars to rescission do not apply for Malaysian law, but Section 65 and Section 66 for restoring benefit do apply. In a nutshell, the approaches of the English and Malaysian law of contract towards the doctrine of undue influence as a vitiating factor is relatively similar, since the Malaysian law has adopted aspects of the English common law. There are differences such as the emphasis on actual and presumed undue influence, but more similarities like the remedies for undue influence and third parties. So I hope all of you enjoyed our video presentation. Thank you.